There are implied terms laid down in sections 14 to 17 of the Sale of Goods Act 1957. Those implied terms are implied condition as to title, implied warranty that the buyer shall have quiet possession of the goods, implied warranty that the goods are unencumbered, implied condition that in sale of goods by description, the goods must correspond with the description, the goods must be reasonably fit for purposes for which the buyer wants them, the goods must be of merchantable quality, and in contract for sale of goods by sample, implied conditions are as follows. The bulk shall correspond with the sample in quality, whereby the buyer have a reasonable opportunity of comparing the bulk with the sample before acceptance, and the goods are free from defect, rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. Implied terms as to time. Section 11 of the Sale of Goods Act 1957 provides, time is not deemed to be of the essence of the contract of sale unless specified. Thus, if a buyer fails to pay by an agreed date, it does not automatically entitle the seller to repudiate the contract unless some term of the contract allow him to do so. However, if time of delivery is the essence of the contract, the party can repudiate the contract and claim damages. Implied term as to title. Unless different intention is shown in the contract, Section 14, paragraph A states that the seller must have a right to sell the goods. There is an implied condition that the seller has the right to sell the goods in the case of sale, or in the case of agreement to sell, the seller will have the right to sell the goods when the time comes for the buyer to become the owner. Perhaps, in order to understand better, it is best to look into the case of Roland and Duval. In this case, Roland bought a car from Duval and used it for 4 months before discovering that it had been stolen. Roland then had to hand over the car to the true owner. The issue in this case is whether Roland could recover the full amount he had paid to Duval, even though he had used the car only for 4 months. The court held that, although Roland had used the car for some time, he was entitled to recover the full price he had paid, because Duval had no right to sell him the car since it was stolen. Implied warranty as to quiet possession. Section 14, paragraph B provides, buyer shall have and enjoy quiet possession of the goods unless specified otherwise. The purpose is to cover the buyer against interference by a stranger, that is a third party, claiming lawful rights by virtue of a better title than the seller, as well as wrongful act of the seller himself. Implied warranty that the goods are free for encumbrance. Section 14, paragraph C provides that goods must be free from any charge or encumbrance in favor of any third party not declared or known to the buyer before or at the time when the contract is made. Implied condition that goods must be in accordance with the description. Section 15 provides that in the case of a contract for the sale of goods by description, there is an implied condition that the goods shall correspond with the description. If the sale is by sample as well as by description, it is not sufficient that the bulk of the goods correspond with the sample if the goods does not correspond with the description. Sale of goods by description covers all cases where the buyer has not seen the goods, but is relying on the description alone. For example, ordering a personal computer by phone. In the case of Varley against Swift, the buyer purchased a second-hand reaping machine without ever seeing it. The seller had described it as new the previous year and used it to cut only 50 or 60 acres. However, the machine was in fact very old. It was held that since it was a sale by description, and since the machine did not correspond with the description, the seller was in breach. Section 16, subsection 1, paragraph A states that there is implied conditions that the goods are reasonably fit for purpose. There are few requirements that needs to be fulfilled. Firstly, the buyer must make known, either expressly or impliedly, to the seller at or before the time when the contract is made, the particular purpose for which the goods are required. Secondly, the buyer relying on the seller's skill and judgment. Thirdly, The goods are of description which is in the course of the seller's business to supply. And lastly, specific goods must not be sold under their patent or trade name. No further indication is required where the goods serve only one purpose. Where the goods are to be used for special purpose, it should be clearly stated. If it's not stated, no breach of implied condition if the goods are suitable for any purpose reasonably foreseeable. In the case of Griffith against Peter Conway Limited, a woman with unusually sensitive skin bought a coat without disclosing the fact to the seller. It turned out to be that the goods, which is the coat, afflicted her health. The court held that the woman could not succeed as the coat would not harm a normal person. Implied condition as to merchantable quality. This condition is provided under Section 16, subsection 1, paragraph B. In the case of David Jones against Willis, the court held that the heels of a pair of shoes they came off on the third occasion was unmerchantable. The goods were defective for the purpose for which they were sold. So what is unmerchantable? Or what is merchantable quality? Merchantable quality means the goods must be reasonable for the purpose described. There are few factors to be considered. Firstly, price. Secondly, the description applied to the goods. Thirdly, whether the purpose for the goods have been made known to the seller. And lastly, any other circumstances relevant to the sale. Implied conditions that the goods must be in accordance to the sample. In a sale by sample, a sample is used to describe the goods to the buyer. Under Section 17, subsection 1, in order to determine whether there is a contract of sale by sample or not, it is best to refer to the terms of the contract, where the terms of the contract can either be expressed or implied. Section 17, subsection 2 states that, in the case of a contract for sale by sample, there is an implied condition that the bulk shall correspond with the sample in quality. The buyer shall have a reasonable opportunity of comparing the bulk with the sample. And lastly, the goods shall be free from any defect, rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. If the bulk of the goods is totally inferior to the sample, the buyer may elect to reject all goods. However, if the bulk is partly inferior, the buyer may choose to accept all goods and claim damages for those which are inferior, or reject all goods and claim for damages.